This evening, he will head to Colorado High School to teach mock trial to students who sometimes get a little heated, but always come out on top. Mackenzie Brackman is sitting in his dining room. Behind him, his kitchen. Next to him, his living room. This is Mackenzie Brackman's home. He lives alone, no family in the house, not even a dog. His house is always quiet, except for the noise of him typing in preparation for the next mock trial tournament, or the occasional neighbor saying hello. On Mackenzie Brackman's front door, he has a Ring video doorbell. It tells him when packages arrive, which friends are at the door on game night, what animals are passing by, and anything else that is the culprit of the movement turning on the motion sensors. A person is now approaching Mackenzie Brackman's front door. This person is not recognizable Mackenzie Brackman. Maybe it's because they are wearing a mask. An old Halloween mask, maybe? Mackenzie Brackman doesn't know what to do. Does he attempt to hide? Does he attempt to talk to the person? What is this person here for? Mackenzie Brackman, amidst the panic, goes to his kitchen in hopes of finding a knife. This masked person, though, is a mock trial student just here to take revenge after being kicked off of Brackman's team. This masked person, this is Avery Becker. Avery Becker has no intention of killing Mackenzie Brackman. It's the middle of the day, so it's safe to say he isn't home. Yet, he is. Avery Becker tries the front door. Locked. This is where the motion sensors are activated. Avery is now heading to the back sliding doors. They open. Inside these doors stands a Mackenzie Brackman, holding a knife in fear of this masked perpetrator. As soon as Avery enters the house, they are met with Brackman holding a knife. They are fighting, trying to gain control, trying to gain leverage over the other person. They are fighting, scuffing at the floor, just trying not to get stabbed. The struggle has now moved to the dining room. Avery Becker is slowly gaining the upper hand, until finally, Avery has control of the knife. As Brackman slowly constrains Avery, Avery reaches behind him and stabs him in the back. This was not part of the plan. Mackenzie Brackman lays there with a knife in his back. He is trying to reach his front door. He reaches behind him and pulls out the knife. This seems like a logical decision, yet it was the decision that caused him to bleed out rapidly. He lays there, lifeless, his front door cracked open, blood staining his shirt, and his own knife laying next to him. After March 6, 2020, the lives of everyone who knew Mackenzie Brackman would be forever changed. That'll show him. This is what Avery Becker said in text messages to Alex Cifuentes. Avery was kicked off of Mackenzie Brackman's mock trial team. So, in her own words, the plan was to trash his house. A popular defense attorney and someone who volunteered his time for the next generation of lawyers, he is no longer here. Avery Becker said that they would show Mackenzie Brackman, and they most certainly did. So now, we ask you to hold Avery accountable for their actions. Thank you.
All right, thank you. Fence, have an opening statement?
Yes, Your Honor. Have you ever had a pleasant dream descend into an inescapable nightmare? One moment you're having fun, floating, free, and the next you're stuck, sinking, scared, trapped in a world where nothing you do matters and the people who are supposed to care don't. On March 6, 2020, Avery Becker's day could have been mistaken for a dream until she learned that she was living in a nightmare from which she has yet to wake. A nightmare where nothing she does matters because no one cares. She tells the police that she will never commit a murder. They don't care. She provides an alibi witness, and they don't care. She and her lawyers go so far, they even provide a much more plausible suspect, and they don't care. They don't even investigate. Ladies and gentlemen of the jury, today we are asking you to care. May it please the court, Your Honor, opposing counsel, and members of the jury. My name is Kira Graham, and along with Liam Anderson and Caroline Dieter, we represent Miss Avi Becker. Today, the prosecution must prove each one of the elements of first-degree murder. That Avi Becker, while in the state of Colorado, alone or with someone else, committed or attempted to commit second-degree burglary, and during that crime, caused the death of Mackenzie Brackman. The prosecution must prove each one of these things individually beyond a reasonable doubt. But the defense does not have to prove anything. No, the burden of proof solely lies upon the prosecution. And after today's trial, you will see that they failed to prove that Miss Becker killed Mackenzie Brackman, that she committed or attempted to commit second-degree burglary, and they failed to prove that she was even there. Today, you will hear from 6 witnesses. From the defense, you'll hear from Professor Blake Van Owen, an expert who will tell you how the police chose a narrative and they stuck to it, even cherry-picking through the evidence and choosing what fitted and ignoring what did not. You will hear from the defendant, Miss Avi Becker, and her best friend and alibi witness, Taylor Perkins, how they woke up, discovered that Miss Becker's phone was missing, so they spent the entire day retracing the steps of the night before to try and look for it. They combed to the mall, and they combed to the fry shack, but to no avail. They called and texted the phone, but to no avail. Why? You will know why when the prosecution's witness, Miss Alex Cifuentes, testifies that they were one of the last people to have the phone before it went missing, and how, conveniently, they got messages from the exact missing phone incriminating Miss Becker of this crime. Messages which you'll hear Detective Markowitz testify the police did not even bother to make sure were true. And finally, you'll hear from Kyle Kuzak, who will tell you how, when it comes to the evidence the police did make sure were credible, they lost and corrupted, leaving today's case incomplete. Today, you will hear about several trails the police failed to follow up on. Like the third suspect Miss Becker supplied, a Blair Rollins, who was known for hating Mackenzie Brackman for putting her father into prison, and who conveniently was best friends with Alex Cifuentes, who was known for feeling threatened by Miss Becker and who wanted her off the mock trial team. This seems important, so why didn't the prosecution investigate this? Well, because they didn't care. Because it didn't fit their narrative. You see, the prosecution did not want the truth. They wanted an easy blame. And so they painted the defendant as a murderer and said good enough. If at any time today you decide that they did not frame Miss Avi Becker well enough, that their paint job has flaws, or that there is reasonable doubt in any of the elements we listed earlier today, your verdict must be for Avi Becker. Please wake her up from this nightmare. Thank you.
All right, thank you. Are the people ready to call their first witness?
We are.
All right, you can proceed.
Your Honor, we call to the stand Jordan Markowitz with the preferred pronouns he, him.
All right.
Hello, Detective Markowitz. Could you introduce yourself to the jury?
Yeah, hello, my name is Jordan Markowitz. I work for the Denver Police Department.
And Detective Markowitz, what do you do for the police department?
I'm a homicide detective with specialized training and experience with cell phones.
And how long have you worked there?
I started my career with the DPD roughly 13 years ago, and I've been a detective for 7 of those years.
And as I mentioned previously, you have specialized cellular training. Could you tell the jury more about what that means?
Sure. I have a forensic data recovery and cell phone technology certification from the American Academy of Law Enforcement.
And would you say you use this training often?
I use it constantly. I've downloaded the contents of hundreds of phones.
Your Honor, I now submit Detective Markowitz as an expert in homicide investigation and cellular forensics.
All right, any objection or voir dire?
Yes, Your Honor, a brief voir dire.
Go ahead.
Detective Markowitz, you're being offered as an expert in homicide investigations, correct?
Yes, I have a wealth of experience.
That's right. You claim to have experience, but you never detail how many cases you've worked on, correct?
Well, the true number is incredibly high. I haven't specifically counted each one, but I've been a detective for 7 years, and I worked as a police officer for 13 years as a grand total.
And in your previous testimony, you never stated what type of detective you even are, did you?
I believe I said I'm a homicide detective.
And you never stated how long you've worked as simply a homicide detective. Only how long you've been a detective, correct?
I believe I've worked as a homicide detective for 7 years. But excuse me if I misspoke.
And you also mentioned having training in cell phone analysis.
Yeah, I have a forensic data recovery and cell phone technology certification from the American Academy of Law Enforcement. I had to complete a training course and pass a certification test. And
Yes, and that course was just 3 days, wasn't it?
It was a 3-day intensive course, but I've also had the experience of downloading cell phone information and obtaining cell phone data in many cases.
And you would agree that cell phone analysis is a complicated field, correct?
I'd say it's a rather complicated field, which is why I'm thankful for the training and experience I have.
No further questions, Your Honor. At this time, the defense objects to Jordan Markowitz's entrance as an expert in homicide investigations as well as cell phone analysis due to a lack of training, education, and a lack of foundation for his experience.
Response?
As stated in his written affidavit, he's been a homicide detective for 7 years with enough on-site experience to be qualified as an expert in homicidal investigation. Secondly, it's been clarified that he has used his training and has received certification in the training, making him more than qualified to speak on cellular forensics.
Anything further?
Your Honor, the detective testified that he had only received a 3-day course in a field that he himself described as complicated. This isn't enough training, and he hasn't established enough basis for his experience in the field of cell phone analysis or homicide investigation. Just a general time frame.
All right, like the detective, I have not taken even the 3-day course, but I have heard a lot of testimony concerning cell phones. So I would say I have experience that way. You're overlooking that Rule 702 suggests that or provides that an expert can be qualified by knowledge, skill, experience, training, or education. So I find the detective to be an expert in the cell phone analysis certainly would be helpful to the jury and has sufficient work as a homicide detective and a police officer if some of the period of time was not as a homicide detective to provide expert opinion. You can proceed.
Thank you. Okay, moving to the crime in question. Detective Markowitz, when did you receive Mr. Brackman's case?
I was assigned to investigate the death of Mackenzie Brackman in March 2020.
And when were you first alerted of the death of Mr. Brackman?
A passing motorist reported seeing a person passed out on the porch of a residence, 444 South Flower Street. I responded at around 2:20 p.m.
And when you arrived on scene, what did you first see?
Well, the front door was open and the victim was face down on the floor in a large pool of blood. A stab wound is visible on the victim's upper left back shoulder area, and I can see a knife just behind him on the floor. I also noticed a Ring video doorbell.
Upon seeing the doorbell, what did you do next?
I observed 2 more Ring cameras, one aimed at the gate to the backyard and the other aimed at the back door. I entered the residence through the back door, which took me into the kitchen.
And as you walked through the house, what else did you observe?
Next to the kitchen, there was a dining area with a table and chairs. One of these chairs was knocked over. There was a shattered plate on the floor, as well as scuff marks and several small drops of blood.
Now, Detective Markowitz, may I bring to your attention exhibits 5, 9, and 18? Your Honor, permission to screen share as I lay foundation for these exhibits.
You can have the witness look at them, but we can't really show them to the jury until they're admitted.
All right. Detective Markowitz, what are these images?
Exhibit 5 is an image of the knife used to stab Brackman. Exhibit 9 is the shattered plate on the floor, and Exhibit 18 are the scuff marks.
And do you know when these were taken?
Yeah, these were taken on the day of the crime.
And do you know at what time these were taken?
These were taken after I responded, after the victim was murdered.
And were these accurate images of what you personally observed while being on the crime scene?
Yes, these are accurate.
Your Honor, I now move to admit exhibits 5, 9, and 18 as admissible evidence.
Any objection to 5, 9, or 18?
No objection to any of those exhibits, Your Honor.
All right, exhibits 5, 9, and 18 are admitted.
Would you say everything you've done up to this point is standard?
Yeah, I've seen many cases similar, so all the procedures I've described and will describe as I did them have been standard.
Based on the information available at the scene, what conclusions did you begin to draw?
It seemed that the victim had caught somebody breaking into their house and had likely confronted this intruder with a large knife. I believe the intruder got control of the knife and then stabbed.
Objection, Your Honor. Out of the scope of the witness's expertise.
Response?
It's well within the purview of a witness to answer on what conclusions they drew as a detective and as part of their job.
Anything further, Mr. Anderson?
Your Honor, what Detective Markowitz was saying falls under the expert field of crime scene reconstruction, of which I believe the prosecution has an expert witness to testify to, and Mr. Markowitz has not been entered as an expert in crime scene reconstruction.
All right, well, the court doesn't necessarily, there aren't necessarily specific fields for crime scene reconstruction, although there is CSI type work, which would be significantly different from homicide investigation. So the jury has heard what credentials are of this officer, and as a homicide investigator, it's well within the scope of their expertise to testify concerning the ultimate conclusion in this case. So overruled. Go ahead.
All right. Mr. Markowitz, you may continue.
I believe I said that the intruder had somehow gotten control of the knife. It appears that the victim was then stabbed and ran to the or moved to the door, either running away from or after the intruder.
Okay, Detective Markowitz, after you left the scene, what further actions did you take?
I downloaded the information from Mr. Brackman's phone, so I was able to access his Ring account data and see everything that the cameras had recorded on March 6th.
And after this, what else did you do?
I downloaded the rest of the contents of Mr. Brackman's phone, and I found out he was a high school mock trial coach for Colorado High School. I reached out to the school and spoke with a student named Alex Cifuentes, who was on the team. He told me that another student on the team had texted something about a plan to vandalize Mr. Brackman's house.
Objection, Your Honor. Hearsay.
Response?
It is within his own knowledge of what he personally said and what conversations took place that he was privy to as he was part of the conversation.
Anything further?
Your Honor, while he may have knowledge of this, that doesn't change the fact that this was an out-of-court statement and it's being offered for the truth of the matter asserted and is therefore hearsay.
Your Honor, may I respond?
Sure.
Your Honor, this refers to a statement of interest made by the defendant and is thus not applicable to being objected through hearsay, as it is relevant through what is the defendant's statement of interest.
All right, I believe you've hit on the right exception there at the end concerning party opponent, so I'll allow it.
All right. Now, when you found out from this information from Cifuentes, then what occurred?
I had Alex and his parents come to headquarters to conduct a full interview. Turned out that the other student was named Avery Becker. She had recently been kicked off the mock trial team after she vandalized Mr. Brackman's car.
And when you asked him further, what did he claim happened between the two?
Avery sent a text to Alex pleading for help getting back on the team. When Alex replied that Mr. Brackman wouldn't.
Objection, Your Honor, hearsay.
Response?
Again, Rule 702, or 703, that hearsay doesn't apply to Avery Becker's statement of interest, and as it is particularly interesting in this case, it is not applicable to a hearsay objection.
Yeah, but the question is who is making the statement? It's not the defendant, is it? I mean, it's not, you're not relating what the defendant said.
Your Honor, may I respond?
Sure.
I do agree that the statements made by the defendant are within the exception to hearsay. However, the witness was about to detail statements made by Mr. Cifuentes, which are not within the exception to party opponent.
Anything else, Ms. Simon?
No further response, Your Honor.
All right, I'm sustaining that objection. A statement by a party opponent has to be of the party opponent or a person authorized to make the statement for the party opponent, and we don't have that here, so sustained.
All right. May I proceed with the rest of my questioning?
Sure.
Did you require any proof of this exchange?
I asked to look at Alex's phone, but he had not brought it with him to the interview. So instead, I had him send me screenshots the next day.
Now, Detective Markowitz, is it common to have evidence in the form of screenshots?
Definitely. I mean, it might be the only time I've encountered a teenager who did not have their phone on them, but people can get stressed out meeting with the police and they can act differently from how they normally would.
After seeing these text messages, did you reach out to Ms. Becker?
Of course. I contacted Avery immediately and I arranged for her to come down to the station for an interview. But just before we were supposed to meet, her attorney informed me that she would not be making any appearances. I had obtained a warrant to search Becker's cell phone, but I learned that she had supposedly lost it on March 5th.
Once you knew the phone was gone, what other means did you pursue to find out about the texts?
I was provided with the cell phone number, so I got a court order to obtain the call detail records, or CDRs, for March 6th.
Now, Detective Markowitz, could you please explain to the jury exactly what CDRs are?
Sure. So a cell phone constantly reaches out to the towers it can communicate with, even when the phone's not in use. So when you place or receive a text message or send or receive a call, a record of that interaction is created, and that's known as a CDR.
So could you tell us how CDRs would be relevant to this Mr. Brackman's case?
Sure. So the record will show things like the date and time of the communication, if it's incoming, outgoing, if it was a phone call or a text message, the duration, if it was a phone call, and additionally the cell tower that the phone's communicating with.
May I now refer you to exhibits 15 and 16? Detective Markowitz, what are these images?
These are the images of the cell phone towers that Ms. Becker's phone was in communication with.
And are these images an accurate representation of the data you received off of Ms. Becker's phone?
Yes, these are accurate representations.
Your Honor, permission to publish these exhibits, or no, Your Honor, permission to move exhibits 15 and 16 as admissible evidence.
Any objection to 15 and 16?
Yes, Your Honor. Objection as to hearsay on both 15 and 16.
Response?
It is not hearsay. It is simply a diagram of the objective facts received from Avery Becker's phone, not taken from anybody else, but simply a cell phone data explanation.
Yeah, I'm going to have to agree these are not statements. I'm not sure they contain hearsay information. From what I can tell, that would constitute a statement under Rule 803, so overruled.
All right. Your Honor, permission to share and publish exhibits 15 and 16 to the jury.
Sure.
Now, Detective Markowitz, what are these images? Or what do these images show?
These images show the cell towers that Avery was communicating with, and the one on the right shows the route I believe she was most likely to take to get to Mr. Brackman's home.
All right, now what other information can you obtain from these two diagrams?
Well, the first communication was received by a tower nearest Avery's house, implying that her phone was somewhere nearby. The next communication was received by a tower on Rock Creek Parkway, the road she would most likely take to get to Mr. Brackman's. And then the final two calls came through the cell tower that is nearest Mr. Brackman's home, placing the phone now near the scene of the crime.
Now, Detective Markowitz, how would you interpret, or finally, Detective Markowitz, based on your years of experience and knowledge of cases like these, what were your final conclusions of the case?
Based on the evidence we collected on and off the crime scene, along with the suspicious location discrepancies, it's absolutely clear that Avery Becker went to Mackenzie Brackman's house on Friday, March 6th, 2020, to break in and vandalize the house. When she was confronted by an armed Coach Brackman, she acted in a rash way, ultimately resulting in the murder of Mr. Brackman.
Thank you. No further questions.
All right, any cross-examination?
Yes, Your Honor. Good evening, Detective Markowitz. My name is Liam Anderson. I'll be asking you some questions today.
Good evening.
Let's start at the crime scene. You were one of the first detectives on the scene, correct?
Yes, I was one of the first detectives to respond after the paramedics had initially showed up.
And you began your investigation as soon as you arrived, didn't you?
Yes, I immediately started taking in the scene. I saw that, like I said before, that the victim was face down on the floor in a large pool of blood. There was a knife on the floor.
And then while you were at the house conducting your investigation, you took pictures, didn't you?
I don't believe I personally took pictures, but the forensics team did.
Yes, the forensics team, which you were in charge of, correct?
Forensics is not my specialty, so I generally just let
Are you
them.
the lead detective on this case, Detective Markowitz?
I'm the lead investigative detective on this case.
These pictures that your team took were pictures of purported blood splatter and blood drops, correct?
Yeah, I believe one of them was a cast-off splatter, and the other were several small drops of blood that I saw in the dining area. I'm not an expert in cast-off splatter, though, so.
But those pictures aren't here today, are they?
No, there were some technical issues, which I'm sure is relatable to everyone now in this pretty technological world.
And those pictures were corrupted, correct?
Yes, like I said, there are some technological issues, but I was able to see them, and so was our crime scene reconstructor specialist before they were corrupted.
And they were corrupted while in your care, correct? Or rather, your team's care.
Well, what I've been saying, like before, is these technological issues, you can't foresee them. There's very little.
Detective Markowitz, that wasn't my question. They were corrupted while in your care, correct?
Yes, I suppose so, understandably.
Detective Markowitz, you interviewed Alex Cifuentes as part of your investigation, didn't you?
Yes, I had Alex Cifuentes and his parents come down to the crime scene to conduct an interview.
And during that interview, you asked Mr. Cifuentes to see his phone in order to see his text messages with Avery Becker, correct?
Yes, I did ask to see his phone, but apparently there was a battery issue and he was also likely very stressed out, so he had forgotten to bring it with him. But I did have him send me accurate screenshots the next day.
Yes, and you even thought that Cifuentes forgetting his phone was weird, correct?
Well, I wouldn't say particularly weird. It was the first time, like I said, I've encountered a teenager without their cell phone, but I learned later there was a battery issue, and meeting with the police can be a very stressful experience, especially for a young kid who is finding out that his friends.
Now, Detective, you talked about how Mr. Cifuentes ended up sending you screenshots, correct?
Yes, he sent me accurate screenshots the next day.
And Mr. Cifuentes is not a police officer, is he?
No, he is a high school student.
Correct, a high school student. And he was not supervised by a police officer when taking these photos, correct?
I don't see why he would have tampered with them, if that's why you're getting at. I have no evidence or reason to suspect they were tampered with. But no, we did not provide a police escort to this young high school kid's house to observe him taking these screenshots.
Detective Markowitz, are you aware of a program called Photoshop?
I believe I may have heard of it, but I'd like a refresher if possible.
Well, I can explain to you. The program basically helps somebody to edit photos. Do you agree with that statement?
If you could elaborate a little more, that'd be good, but I agree with that general statement.
And did you confirm in any way that Mr. Cifuentes did not have access to Photoshop?
Well, I have no evidence or reason to suspect that these were tampered with.
But you have no evidence to show that they were not tampered with, do you?
I don't see why a high school student would try and set up a friend.
Detective, there were 3 suspects in this case, correct?
I'd say there was one main suspect that, when I followed the evidence, was presented.
However, you initially named 2 other suspects, correct?
I'm sorry, I can't think which suspects you might be referring to. Could you specify?
Specifically, I'm referring to Blair Rollins. She was initially considered a suspect, correct, and later ruled out.
I don't believe she was initially considered a suspect. I said I believed it was unlikely that it could have been the work of a disgruntled ex-client.
You never contacted Blair Rollins, did you?
Like I said, when I turned to the evidence, I followed up on the evidence. There was no reason to contact Blair Rollins.
Moving on to the call detail records, you were informed by Ms. Becker's attorney that Becker had lost her phone, correct?
Yes, I was informed of that. I just wish she had came down to the station to conduct an interview so I could have followed up further on that. I wish she had cooperated, but
so you collected the call detail records for Avery's phone after you heard that, correct?
Yes, I was provided the phone number, so I got a court order to obtain the call detail records, or CDRs, for March 6th, 2020.
And as part of this investigation, you could see which towers Ms. Becker's phone had connected to, correct?
Yes, we could see the towers that her phone was communicating with throughout the day.
And you created a diagram that we previously saw in exhibits 15 and 16, showing these towers, the direction they pointed, and your perceived location of the defendant's phone, correct?
Yeah, I believe I mapped out the route I believed the defendant was most likely to take to arrive at Mr. Brackman's house.
If co-counsel could please pull up exhibit 16. Now, you drew some red arcs on this exhibit, correct?
So marks, yes, that is part of the diagram. It shows that sort of 120-degree arc that all cell phone towers have.
And this is where you think Ms. Becker's phone was, correct?
Based on the data, these are the cell towers the phone was communicating with. I drew a map of the route she would most likely take to get to Mr. Brackman's home.
Detective Markowitz, a phone can connect to a farther away tower for any number of reasons, correct?
It'll generally connect to the best tower, and that's almost always the tower that it's nearest to.
However, the traffic on a certain tower can cause a phone to connect to a different tower, correct?
I suppose so, but I think it'd be nothing short of miraculous that her phone would originally connect to the one nearest her house, then the one on the road she would likely take to get to Mr. Brackman's home, and then the tower nearest Brackman's home.
So you can't be 100% certain that the phone was within these drawn radiuses, can you?
We can say to a high degree of certainty that the phone was
You cannot be 100% certain that the phone was within these drawn arcs, can you?
All right, hold on. Mr. Anderson, you're a little short on letting the witness finish the answer, please.
Yes, Your Honor.
Go ahead. Finish your answer first, then we'll get to the next question.
Yes, I believe I was saying we know for certain that these are the towers it was communicating with, and we can say to a high degree of certainty that her phone was within the area of these towers.
Now, did you also pull the call detail record location records for Ms. Perkins's phone?
Ms. Perkins' phone, like I said before, her, the lawyer informed me that Avery would not be making an appearance. So if she had cooperated and communicated with me, I might have been able to check that out. But sadly, she did not. I believe it was likely because she was worried she would somehow slip up.
Detective Markowitz, that wasn't my question. I asked you if you pulled the location records for Mr. Perkins's phone.
For Mr. Perkins's phone, I don't believe. I'm sorry. Would you repeat the question one more time? I'm really terribly sorry.
You didn't pull the location records for Mr. Perkins's phone, correct?
No, we did not pull the location records, but we knew that the phone was communicating with Avery's phone throughout the day.
So you chose not to collect evidence of an alibi witness's location that night, correct?
Well, the alibi, like I said before, we were not informed of because Avery refused to cooperate with us. And we did, in fact, investigate the potential murderer's phone. So we knew that it wouldn't have.
So you thought Mr. Perkins's location wasn't relevant?
No, we didn't think it wasn't relevant, but he could have been anywhere. And it wouldn't necessarily mean that Avery was there with him.
So you thought it was relevant, but you didn't collect it then?
I'm saying it's relevant to the alibi I was not informed of until because she refused to cooperate, but we did look into Avery, the actual suspect's CDRs.
Thank you, Your Honor. No further questions.
Any redirect?
Your Honor, may I do a brief redirect?
Yes.
All right, Detective Markowitz, were you informed that Taylor Perkins was in fact Avery's alibi?
No, I was not informed. Like I've said, she refused to cooperate with me. Likely, I said this is likely because she was worried she might slip up in this interview. So
While
it's not.
Sorry. While doing your investigation, did you need to look into Taylor Perkins' phone?
No, we most certainly did not, as we were not. We had ruled out Taylor Perkins as a possible murder suspect.
Detective Markowitz, were you directly responsible for the photos of blood spatter?
I most certainly was not directly responsible.
And is it common for students to get nervous when interviewing with police?
Yeah, I'd say it's pretty common, especially when you're a young high schooler and you found out that your friend might have murdered somebody. I can see how they would get stressed out.
And Detective Markowitz, could you speak on the likeliness of a cell tower connecting with 3 separate towers away from it?
I can say that it's highly unlikely that it would connect with all 3 of those towers. It'd be nothing short of miraculous.
And what would be plausible for a phone to connect with?
The phone would normally connect with the nearest tower, given that it's almost always the best available tower.
All right, no further questions. Thank you.
Any recross?
No recross, Your Honor.
All right, thank you. People's second witness.
Your Honor, we now call to the stand Alex Cifuentes. Hello, Ms. Cifuentes. Could you introduce yourself to the jury?
My name is Alex Fuentes, and I am a current senior at Colorado High School.
And what was your relationship to Mackenzie Brackman?
He was my mock trial coach since freshman year.
And how long did you say you were on mock trial?
Since freshman year, so that would be about 4 years.
And did you respect your coach, Coach Brackman?
I did. I think that not only was he a good
Objection, Your Honor. Relevance.
Response.
I'm laying foundation for the relationship of Alex Cifuentes to her coach and her other teammates.
Anything
Mayor?
further?
Yes, may I respond?
Sure.
Your Honor, I fail to see how Alex Cifuentes being respectful to her coach is relevant to Alex's relationship with the other teammates.
Anything else?
Your Honor, I'm simply laying foundation for a student-coach relationship here.
Well, we'll have to let this play out. Please get to your point, but I'll allow it as foundational. Overruled.
Yes, Your Honor.
And why did you join mock trial, Ms. Cifuentes?
Originally, I had joined mock trial because Avery brought up the idea, and I eventually really enjoyed it, so I stuck with it throughout high school.
And what was your relationship with Avery Becker?
We were really good friends in freshman year, but as most friends do, we just kind of grew apart, but we're still decent friends.
And why was Avery such a bad mock trial teammate?
She was pretty unreliable. She really wouldn't study, I guess, and like it was really difficult for us to rely on her and know what she was thinking and doing because she always came to practice unprepared and really would just wing everything.
And were you ever jealous of Avery when it came to mock trial?
I was jealous of her because I spent so much time studying and practicing and learning the case, whereas she would spend maybe half that amount. And I feel like anyone would be jealous of someone who got rewarded for doing something or for doing half as much work as you did.
And how far would this jealousy go?
Nowhere. I would use it to push me and to make me a better mock trial student because their mock trial wasn't fair, so there really wasn't anything I could do about it.
And from your point of view, what was the relationship between Avery and Mr. Brackman?
From what I could tell, it's pretty hostile. They were constantly arguing, really never seeing eye to eye. They got to a point that they were, when Avery was kicked off the team, she vandalized his car.
And were you talking with Avery after she vandalized his car?
I was. She had texted me and asked me.
Objection, Your Honor, hearsay.
Response?
The witness is testifying to a statement of interest made by the defendant.
Anything further, Ms. Dieter?
Well, if this is in reference to the text messages, those have not yet been verified to have been sent by Ms. Becker, so I'm not entirely sure that that would count under that exception.
Yeah, I don't think we have, I believe, Exhibit 14 in evidence, do we?
No, we do not.
So that's your problem.
Your Honor, I can publish Exhibit 14 to the
Well,
jury.
it's not been admitted yet. You need to, it's not a matter of publication. It was not admitted through the last witness.
Your Honor, may I respond?
Sure.
Your Honor, I'm currently in the process of laying adequate foundation before I enter Exhibit 14 as admissible evidence, but if you would prefer, I can admit it right now.
Your Honor,
Well,
may I respond?
Go ahead.
Your question was asking Ms. Cifuentes to recount what was said in these texts. I would not consider that to be foundation, but rather going straight to the point.
Frankly, I would too. So
Yes, Your Honor.
the objection is sustained. Move on.
Okay, Your Honor. And what is your relationship with Blair Rollins, Ms. Cifuentes?
She was a student in the high school that I went to, and we see each other in the halls, but other than that, I barely see her.
And Ms. Cifuentes, finally, do you have anything to do with Mackenzie Brackman's murder?
No, I loved my coach. I think he was an amazing coach and an amazing lawyer, and I don't think that, I mean, it's shocking that anyone would think that I could be capable of what they're saying that I am, because that's not me and I know it.
No further questions, Your Honor.
All right, any cross-examination?
Yes, Your Honor. Good morning, Ms. Cifuentes. My name's Caroline Dieter, and I'm going to be asking you some questions today. If you could keep your answers to a short yes or no, that would be ideal. To start off, I would like to discuss your relationship with Ms. Becker. You did mock trial with her for 3 years, correct?
Since freshman year, we were on the same mock trial team.
That's not what I asked, Ms. Fuentes. Did you do mock trial with her for 3 years?
Yes, I did.
And she, in fact, you said, was the one who encouraged you to join, wasn't she?
Yes.
That being said, though, she still got on your nerves quite a bit. Isn't that right?
I mean, yeah, she would come unprepared to practice, and that frustrated me. It frustrated the whole team. It frustrated coach. It caused a lot of anxiety.
I apologize. Continue.
Well, it caused a lot of anxiety throughout the team, and when it got to tournaments, we really didn't know where she was going to go. And
so yeah, it did frustrate you quite a bit. So much so that you would ask Mr. Brackman over and over again, wondering why he put up with Miss Becker, correct?
Well, she, no matter how much she didn't study, she was able to make it up on the fly, and she
Miss Fuentes, I'm asking if you asked Mr. Brackman, not reasoning as to why you might have.
Yes, I asked him why he
Thank you.
allowed her to stay on the team.
And Miss Fuentes, you thought Miss Becker refused to work hard, isn't that right?
I did not say refused.
Is it your testimony here today that you did not, in fact, say that Miss Becker refused to work hard?
I think that she tried. Well, I mean, I think she was kind of just making it up.
Miss Fuentes, is it your testimony here today that you did not say?
Objection, Your Honor. Asked and answered.
Well, it was asked, but it wasn't answered. Let's hear the answer.
Can you repeat the question?
Yes, of course. Is it your testimony here today that you did not, in fact, say that Miss Becker refused to work hard?
Prior to you asking me that question, I never specifically said that she refused.
And you made a statement before coming here today?
What statement? My witness statement?
Yes.
Yes, I did make a witness statement.
And you signed that statement?
I did.
You signed that it was true?
Yes.
Accurate?
Yes.
And up to date?
Yes.
And that you would update it should any new information come to light?
Yes.
And in this statement, you say that Miss Becker did refuse to work hard, don't you?
In my witness statement, I said that she did refuse to work hard, but when I was talking to the prosecution, I never said that she refused to work hard.
I see that you've been confused by my question, so I will move on. Now, Miss Fuentes, you were at the Fry Shack the night before the murder, correct?
Yes, the mock trial team was there.
And Mr. Perkins and Miss Becker were there as well?
They came in a little bit after we did.
And did you speak to Miss Becker?
Yes, she
let you use her phone before she left, did she not?
We were talking and she allowed me to play.
Miss Fuentes, I'm asking that from this point on, you continue to keep your answers to a simple yes or no.
Well, Ms. Jeter, you're going to have to ask a yes or no question then.
I believe
Otherwise,
I did.
You did not, so please let the witness finish. If you can ask a leading question, you're allowed to, but that was not.
My apologies. Ms. Fuentes, you may continue.
Can you repeat the question? I don't remember what I was saying.
Frankly, I feel that if I repeat it, I will make it leading. So I would like to just move on. Did you used Miss Becker's phone before she left, correct?
To play, yes, correct.
And Miss Fuentes, later on in the course of this investigation, you offered screenshots of a supposed text conversation between yourself and Miss Becker, correct?
Yes, I did.
And those texts were the entire reason that you had to do a full in-person interview, correct?
Along with other things, but that was the main reason.
And yet, you still forgot your phone that held these alleged screenshots or these alleged texts, correct?
Yes, may I explain?
You will have a chance to do so on redirect if you so choose. And Ms. Cifuentes, Detective Markowitz did not make you verify these, correct?
They were from my phone, and they are authentic screenshots.
And they are still being shown here in court today, regardless of the fact that you did not have to go back and verify.
They said screenshots were okay, so after I sent them and they looked over them, I was never asked to come back down to the station.
Thank you. No further questions, Your Honor.
All right, any redirect?
Yes, Your Honor. Ms. Cifuentes, how come you didn't show the detective your phone with a text exchange between you and Avery on it?
Well, it was a very old phone and it was losing battery very quickly, and I had put it on the charger before I left to make sure that I could bring it down to the station. And when I was racing out the door, I forgot it, and they told me once I got to the station that it was okay and that screenshots were completely fine.
And where is this phone now?
Well, like I said, it was very old, and I decided to exchange it for a new phone, and those text messages never transferred over to my new phone.
Okay. Your Honor, we now move to admit Exhibit 14 as admissible evidence.
I'm sorry, you're moving to admit.
Exhibit 14.
Any objection? Any objection, Ms. Dieter, to 14?
I apologize, Your Honor. I was muted. Yes, to hearsay.
Response?
Again, like my co-counsel stated earlier, this is a statement of interest made by the defendant. Therefore, it is not applicable to hearsay.
Anything further from the defense?
To be clear, we are speaking of the text messages, correct?
That's Exhibit 14, yes.
Yes. Once again, these have not been verified to have been sent by Ms. Becker definitively.
All right, response to that?
Earlier in my direct examination, we had Alex Cifuentes confirm this text exchange between Avery and Ms. Cifuentes herself.
May I respond, Your Honor?
Sure.
Then, even still, Alex Cifuentes' text would not fall under party opponent. So I'm moving that if you don't have a redacted version, that this exhibit not be admitted.
Well, I mean, these are supposedly texts from the defendant. That's the party you're opposed to in interest from the prosecution standpoint. So they do fall under that hearsay exception. There are some problems without having a date, etc., for these texts, but we have sufficient testimony from one of the participants. The court will allow these into evidence, and it's for the jury to determine the weight to be given to this exhibit. So Exhibit 14 is admitted.
Yes, Your Honor.
You can continue.
Thank you, Your Honor. And on the night of March 5th, where were you, Ms. Cifuentes?
I don't exactly remember what date was that.
To remind you, the Fry Shack.
Oh, right. Yes, I was at the Fry Shack with the mock trial team, and yeah.
And you had Avery's phone in your hands, correct?
She allowed me to play a game on her phone, and I had it for a short period of time, and then when she was leaving, I gave it back to her.
No further questions, Your Honor.
All right, any recross?
No, Your Honor.
All right, thank you. Further witnesses for the prosecution?
Your Honor, may we call Kyle Kuzak to the stand?
All right.
Hello, Ms. Kuzak. Could you introduce yourself to the jury?
My name is Kyle Kuzak.
And what do you do for your profession?
I am a certified crime scene reconstructor for the Denver Police Department.
How long have you been investigating crime?
I have over 19 years of experience.
Ms. Kuzak, what is your relationship to the Denver Police Department?
I am a civilian employee under the Denver Police Department.
What type of cases have you worked on, Ms. Kuzak?
I've worked on home invasions, burglaries, property crimes, domestic violence, and other armed robberies.
Can you tell us a little bit about how you actually look into and reconstruct cases?
Yes, so first I receive evidence and photos from the Denver Police Department, and I organize and separate the evidence that I've received into different categories, which is then when I begin to analyze and finally come up with my final conclusion.
Your Honor, I now submit Ms. Kuzak as an expert witness on crime scene reconstruction.
Any objection or voir dire?
Yes, a quick voir dire, Your Honor.
Go ahead.
Good afternoon, Ms. Kuzak. My name is Kira Graham, and I'll be asking you some questions. Now, you do not provide any training for your crime scene reconstruction, correct?
I am a certified crime reconstructor.
But you do not mention any training in your statement?
I have over 19 years of experience.
Ms. Kuzak, once again, that's not what I asked. I asked if you had mentioned any training.
I'm not sure if it's mentioned exactly in my witness statement where I got my training, but I am certified, so I have had my training.
You also have not managed to, you have also managed to not provide any knowledge of, you've also not managed to provide any previous experience in being an expert witness?
I believe I've been an expert witness on many cases before.
Is it your testimony today that in your witness statement, you mentioned being an expert witness?
I do not believe in my statement I am an expert witness, but I have over 19 years of experience being a certified crime reconstructor.
Your Honor, at this time, the defense objects to entering Ms. Kuzak as an expert in the field of crime scene reconstruction, because although they have mentioned that she has 19 years of experience, she has not provided any proof or foundation in her witness statement relating to being an expert in the past, let alone an expert in the field of crime scene reconstruction. And so we believe that that is not enough for experience.
Response?
Your Honor, under Rule 702, a witness can be submitted just off of experience, and Ms. Kuzak brings 19 years of investigating through crime scene reconstruction.
All right, there's nothing in the expert witness rule or case law, as far as I'm aware, that prior testimony is a part of expertise. Certainly 19 years is probably, as a crime scene reconstruction expert, is more than I think either of you have had as lawyers. So we'll certainly allow this person to testify as an expert. In fact, it's refreshing to have an expert that doesn't bring along miles of baggage, tons of baggage. You can proceed.
Thank you, Your Honor. Ms. Kuzak, what type of cases have you worked on?
I've worked on cases like home invasions, armed robberies, and other fatal accidents.
When did you first arrive on scene?
I arrived on scene after the crime was first initially processed.
Ms. Kuzak, could you explain Exhibit 9 and Exhibit 18?
Yes, so Exhibit 9 is a picture of a broken plate next to Mackenzie Brackman's kitchen table. And was it Exhibit 18 you said? And Exhibit 18 is a picture of scuff marks near the front door of Mackenzie Brackman's home.
And what is the importance of these pieces of evidence?
These pieces of evidence brought me to my conclusion that there was a struggle between the intruder and Coach Brackman, and Mr. Brackman, and it also led me to believe that this was a burglary gone wrong.
After seeing all the data from the crime scene and observing yourself, how do you personally perceive this crime?
Once again, I perceived that there was a large struggle over the possession of the knife within Mackenzie Brackman's home, and I believe, based off of the evidence I have found, that the intruder and Mr. Brackman knocked over the plate and created these scuff marks during their fight.
And can you tell me specifically how you went about taking and evaluating evidence from this case?
The first thing I did was I received the evidence from the Denver Police Department, and I then created a spreadsheet with different segments based on kind of the organization of the evidence I had received, including exhibits and videos and photos. Then I analyzed this evidence and dove deeper into it. And finally, I prepared and finalized my final reconstruction paper.
After examining all the evidence of this case, what do you believe happened?
I believe that this was a burglary gone wrong, and the intruder entered through the back door, which is evident from the Ring camera footage, and then entered into Mackenzie Brackman's home. But because of the noise that the door initially made when it was opened, Mackenzie Brackman had enough time to grab a knife and defend himself from the intruder. This is when a fight broke out between the two of them, and finally the intruder got possession of the knife and stabbed Mackenzie Brackman in the back.
Thank you, Your Honor. No further questions.
Cross-examination.
Yes, Your Honor. Good afternoon, Ms. Kuzak. Oh, I'm sorry. Before I start, can I please get a quick time check? Good afternoon, Ms. Kuzak. My name is Kira Graham, and I will be asking you some questions. Now, there were no fingerprints found at the crime scene of my defendants, correct?
No, the intruder was wearing gloves.
And was there any DNA evidence found?
No, once again, evident from the Ring camera footage, you can see that the intruder was completely covered from head to toe.
And is it your testimony today that there was no DNA evidence found at the crime scene?
That is correct. There was no DNA.
Did you create a witness statement prior to coming here today?
Yes.
And in that witness statement, you agreed that everything was true?
Yes.
That everything was accurate?
Yes.
And that everything was complete?
Yes.
And in that witness statement, you say that there was DNA evidence found at the crime scene, correct?
Could you be more specific on which DNA evidence you're talking about?
DNA evidence in general, like my original question. Was there any DNA evidence found at the crime scene?
I believe that the intruder was wearing gloves, so there were no fingerprints or footprints found.
I didn't ask about fingerprints or footprints. I asked for DNA evidence.
No, I did not find any DNA evidence.
Can co-counsel please pull up can Your Honor, permission from my co-counsel to pull up the witness's affidavit for purposes of impeachment?
Sure. Want to tell us where in there?
Yes, line 38 to 138 to 139. Ms. Kuzak, please read in your head as I read aloud. All of the fingerprints and DNA we recovered belong to the victim, but that is consistent with the fact the intruder was wearing gloves as shown on the Ring videos. Did I read that correctly?
Excuse me, I think we've called time.
Does the witness have a response to that question?
May you repeat the question? Sorry, I didn't hear it over the timekeeper.
So there was, in fact, DNA evidence found at the crime scene, correct?
There was blood found from the victim, but none from the intruder.
That was not my original question. My original question was if there was any DNA evidence found at all. There was, correct?
My apologies. I thought you were talking about DNA evidence from the intruder, but yes, there was in fact DNA evidence
from Mackenzie Brackman living in his own home.
No further questions, Your Honor.
All right, redirect.
Yes, Your Honor. Ms. Kuzak, is it common for you to work on cases without forensic evidence?
Yes, it's very common. I have many experiences with cases without any forensic evidence.
And are you still able to conduct a thorough investigation?
Objection, Your Honor. Out of the scope of my cross, I never mentioned how valuable DNA evidence was to an investigation, and I also never asked anything about whether anything about her investigation at all.
Response.
Your Honor, this question is regards to forensic evidence. I'm just asking a different question.
All right, I believe the defense has brought up the forensic evidence or lack thereof and the DNA, so overruled, I'll allow it.
And Ms. Kuzak, are you able to conduct a thorough investigation without lots of forensic evidence?
Yes, I am. And especially in this case, there was enough actual evidence where a forensic evidence was not necessary.
And finally, was the DNA only from the victim?
Yes, there was only DNA from the victim at Mackenzie Brackman's home.
Thank you, Your Honor. No further questions.
All right, any recross?
No, Your Honor.
Okay, thank you. People have any further witnesses, or do you rest?
The prosecution rests, Your Honor.
All right, the defense, you want to call your first witness, please?
Yes, Your Honor. The defense calls Professor Blake Van Owens to the stand.
All right, you can proceed.
Good morning, Professor Van Owen. Please introduce yourself and spell your last name for the jury.
You're on mute.
My apologies, Your Honor. Good afternoon. My name is Professor Blake Van Owen. Van Owen spelled V-A-N space O-W-E-N-S, and I prefer the pronouns she, her, and I like to be addressed as Professor Van Owen.
Why are you here today, Professor?
I'm here today as a private investigator and the lead person in charge of investigating police practices for the defense.
And what principles exactly do you investigate in your work as a defense witness and private investigator?
I investigate police practices, cell tower analysis, crime scene reconstruction, and forensic evidence techniques.
And have you ever been entered as an expert witness in a court of law on any of these subjects before?
Yes, I have been entered in U.S. state and district courts over 100 times.
And where exactly did you acquire your expertise?
I have worked as a private investigator, security guard, and school resources officer.
And do you have any education in this field?
Yes, I obtained my master's degree from the University of Ashford in criminal justice.
And what do you do when you aren't working on court cases, Professor?
When I'm not working on court cases, I work as a professor at the University of Colorado, Denver, and I lecture on police practices and social justice.
Your Honor, at this time, the defense moves to enter Professor Blake Van Owen as an expert in fields of police practices, forensic evidence techniques, crime scene reconstruction, cell tower analysis, and police investigation tactics.
Any objection or voir dire?
No objections, Your Honor.
Okay, be recognized as an expert in such areas. You can continue.
Professor, before we start, what's your overall opinion on the case as a whole?
I believe that this case was very rushed. There are a lot of missing pieces and things that simply don't make sense with the prosecution's analysis of this case.
In the course of your investigation, did you get a chance to review the coroner's report?
I did, yes.
And if you, as well as opposing counsel, could direct your attention to Exhibit 19. Do you recognize this exhibit?
Yes.
What exactly is it?
It is the autopsy report done in this case.
And how do you know this?
I know this because I reviewed it upon my investigation.
And lastly, was this report made public?
Yes, in the state of Colorado, autopsy reports are public records.
And is this a true and accurate copy of the report of the autopsy report?
Yes, it is.
Your Honor, at this time, the defense moves to enter Exhibit 19 into evidence as its accuracy has been shown and authenticity stipulated to.
Any objection to Exhibit 19?
No objections, Your Honor.
All right, Exhibit 19 is admitted.
Professor, what are your thoughts on the prosecution's evaluation that there was a struggle taking place when the stabbing occurred?
It simply doesn't make sense. According to the autopsy report, the knife entered the body of the victim at a slight downward facing angle with the blade of the knife facing up. Now, in order for this to have happened, the intruder would have needed to be holding the knife in a fashion so that the grooves of the knife were facing their fingertips and the flat edge was facing their palm. This is inconsistent with a struggle, as in a struggle, as for the knife to have entered the scapula and aorta, the assailant would have needed to apply a great amount of force, and this would simply not be able to happen in a struggle unless the assailant were to be larger than the victim. You see, in this case, according to the Ring doorbell videos, the assailant was not larger than Mr. Brackman, and therefore the idea that the two were involved in a struggle simply doesn't make sense with the evidence brought forth today.
And how exactly did the stabbing take place then, in your expert opinion?
Well, in my expert opinion, and consistent with the autopsy report, the attack was a surprise attack from behind, in which the victim was in a seated position and the assailant surprised the victim, stabbing them in the back.
And why is this discrepancy important?
You see, a surprise attack is much different than a simple break-in. You know, a surprise attack suggests something much more sinister than criminal mischief or vandalism.
Now, if co-counsel could take down the exhibit. Professor Van Owen, we're going to move on to the Ring doorbell videos in this case. Did you get a chance to review those?
I did, yes.
And what are your opinions surrounding the idea of the Ring notifying Brackman to an intruder?
I believe that it doesn't have proof to back it up. You see, the police had access to the user account records of Mr. Brackman's phone, yet failed to use it. They never verified that Mr. Brackman's push notifications were on, and therefore we will never know whether or not Mr. Brackman was alerted by these Ring notifications.
Thank you, Professor. We're now going to move on to the text messages in this case. Did you get a chance to review those text messages?
I did, yes.
And what is your analysis of the collection of these screenshots?
The screenshots brought in by Alex Cifuentes were never verified. It is incredibly easy to doctor screenshots, fake them, change the name of a contact on a phone. There is no way for us to know for certain whether or not these screenshots are real because the prosecution failed to verify them, even though they had the Cellbrite technology to do so. Therefore, these screenshots cannot be trusted.
Now, Professor, we're going to move on to the cell towers. Were you given access to the cell tower reports collected by the police?
Yes, I was.
And we should have Exhibit 15 in evidence if the co-counsel could pull that up.
I'm sorry, can you repeat which exhibit?
Exhibit 15. Professor, when it comes to cell phone analysis, did you find any issues in the analysis of this data?
Yes, I believe that the prosecution is trying to pass off cell tower data for GPS data, in which case it is not. You see, there are many factors that go into determining which cell tower a phone may connect with. Geographical location, whether usage, many factors go into determining this. And a phone can connect with a tower up to 100 miles away. You see, just because Avery Becker's phone connected with a tower near the victim's house does not mean that Mrs. Becker's phone was at Mackenzie Brackman's house.
And what does this mean for the case?
Well, it just goes to show the rushed nature of this investigation. You see, the prosecution never looked into other suspects' phones. They never subpoenaed records for Miss Becker's phone the morning of or night before the murder in order to verify her alibi. And altogether, it was a very one-sided and rushed investigation.
Co-counsel could take down the exhibit, please. Professor, you just mentioned other suspects. Did you form any opinions on possible alternate suspects in this case?
Yes, I did. Upon my investigation, I came upon a much more likely suspect, Mr. Blair Rollins.
And what exactly stood out to you about Blair Rollins?
Well, you see, Blair Rollins' father was represented by Mackenzie Brackman a couple months before the murder. Blair witnessed his father's trial and even testified in court at it. Unfortunately, Blair's father was sentenced to a life in prison, and in my expert opinion, I believe that watching your father be put away for a life in prison is a much greater motive than simply getting kicked off a mock trial team.
And did Blair have any connections to any other suspects?
Yes. According to my investigation, Blair was friends with Alex Cifuentes, and Blair also had a similar height and build to the person on the Ring doorbell videos and was not at school on the day of the murder.
Objection, Your Honor. Speculation.
Response?
Your Honor, this is well within the witness's expertise, and she is basing this off of her observations from her investigation.
Any further, Ms. Blair?
Yes, Your Honor. Professor Van Owen has not witnessed a relationship between Alex Cifuentes or other students to Blair Rollins, and we have not heard anybody testify to this relationship.
Well, I agree. That's not something that falls within the offered areas of expertise, and this is certainly something that the jury can determine for themselves.
Yes, Your Honor, I will move on. So after you discovered everything you previously talked about, Professor, did you come to any overall conclusions for the case as a whole?
Yes, I did. First of all, the stabbing did not occur in the way that you might be led to believe. In fact, it was a surprise attack from behind, which suggests something much more sinister than vandalism or burglary. Next, the cell tower data is not as accurate as you may think. You see, there are many factors that go into determining which tower a phone connects with, and just because Ms. Becker's phone connected with a tower near Mr. Brackman's house does not place Ms. Becker's phone at Mr. Brackman's house. Third of all, the screenshots used in this case were never verified and therefore cannot be trusted. Also, the Ring notifications were never checked to see if they were on, and so there's no way to know whether or not Mr. Brackman was alerted by these notifications. And lastly, the other suspect in this case, the much more likely suspect with a much greater motive, was never looked into, doesn't have an alibi, and was never considered by the prosecution. All of the rushed investigative practices and false assumptions made by the prosecution in this case are what put Ms. Becker in this nightmare in the first place.
Your Honor, I object on grounds of hearsay. As Professor Van Owen said, Professor Van Owen said that Blair Rollins does not have an alibi, yet he is not here to testify to that.
I'm not sure the source for the lack of I've read the witness statements, but I'm not sure of the source for the statement of no alibi.
Your Honor, may I?
Yeah, tell me where it's from.
Your Honor, the initial evidence in this case collected on Blair Rollins was collected by Kyle Kuzak. And then eventually, as the professor testified, she conducted an investigation into the alibi and just the situation surrounding Blair Rollins. And from that investigation, she learned that Blair was not in school and was unable to contact Blair to find an alibi.
All right, anything further?
Your Honor, I ask that be stricken from the record when Blake Van Owen stated that Blair Rollins did not have an alibi, as there is nowhere in anyone's witness statement to verify this.
Well, once again, Mr. Anderson, final chance. Tell me where that came from.
Your Honor, that the no alibi really means that there was it really means that Blair Rollins did not offer an alibi. Blair Rollins effectively disappeared after the murder had taken place, and in the professor's attempts to contact Blair, she could not get an alibi.
All right, so under 703, this witness can testify concerning the type of information reasonably relied on by experts in a particular field, but the fact that we don't have a particular witness available, so under unavailability, including under the hearsay rule unavailability, we don't know whether or not that person has an alibi. Just because we don't have one doesn't mean there isn't one. So I will strike that portion of the answer.
Yes, Your Honor.
Further?
With that, no further questions.
All right, cross-examination.
Hello, Professor Van Owen. You were a former police officer for the Aurora Police Department, correct?
Yes, I worked for the Aurora Police Department for 9 months between 2005 and 2006.
You quit the Aurora Police Department after an incident where you were the arresting officer, correct?
Yes, I resigned after an incident in which I injured a young woman.
Since that incident, you have worked several jobs, true?
Yes.
And one of those jobs was as a defense expert in the U.S. District Courts, correct?
Yes.
In that job, you've consulted on over 100 cases, right?
In my job as a private investigator, I have consulted on over 100 cases. Yes.
As in your job as an expert witness, you have testified in over 6 different U.S. District Courts, correct?
Well, my job isn't an expert witness. My job is a private investigator, and through that job, I have testified. Yes.
Okay. And in all these times as an expert witness where you testified, you've only ever testified on behalf of the defense, correct?
Yes, as is common in my field as a private investigator.
Do you recall how long Detective Markowitz has been on the police force from earlier in his statement?
I believe Detective Markowitz said 13 years, although I could be wrong.
That is correct. And for 7 of those years, he has been a detective. And as you stated before, you worked for the Aurora Police Department for 9 months, correct?
Yes, although I've worked in police practices for over 16 years.
And so you stand here believing that you have the means to call Detective Markowitz, and I quote, defective Markowitz, end quote, correct?
I believe that in this particular case and the way this investigation was conducted was rushed, and that in this case, Detective Markowitz did not provide sufficient evidence. So I did say that in my statement, yes.
Okay. And in your professional opinion, you believe someone broke into Mackenzie Brackman's house with the intention of murder, correct?
Yes, and consistent with the evidence brought forth by the autopsy report.
You also believe the police came to an easy conclusion in a very rushed investigation, correct?
Yes, they picked a suspect and went with them.
And this suspect is Avery Becker, correct?
Yes.
And you believe that Avery Becker became a suspect without the support of evidence, right?
I believe that Avery Becker did not have enough evidence, no.
So you think there is some supportive evidence to create Avery Becker as a suspect?
In my expert opinion, I don't believe that there is strong enough evidence to make Avery Becker a suspect nor convict her of this crime.
And in your opinion, you believe an unbiased police investigator should never assume facts to be true unless proven by evidence, right?
Yes.
And yet, in your witness statement, you said, and I quote, Jonathan Rollins yelled out that Brackman was going to die, end quote.
Objection, Your Honor. Hearsay.
Response?
This is not hearsay, as I am directly quoting Professor Blake Van Owen's statement, and I'm not quoting the audio recording of Jonathan Rollins.
Anything further, Mr. Anderson?
Yes, Your Honor. She quoted a man by the name of Jonathan Rollins. Jonathan Rollins did not write the professor's witness statement, and that statement that Jonathan made was an out-of-court statement.
Anything else, Ms. Blair?
Yes, I was not quoting the audio recording made by Jonathan Rollins, as he did not say this. I was simply quoting what Blake Van Owen wrote that Jonathan Rollins allegedly said.
All right, just taking something and putting it in a report doesn't remove the lesser quality of evidence that is hearsay. However, if this witness relied on that information informing her opinion, she can testify to it.
Thank you, Your Honor. I'll restate the question. In your statement, you said, and I quote, Jonathan Rollins yelled out that Brackman was going to die, end quote, correct?
Yes, upon reviewing the full court proceedings from Jonathan Rollins' case, I heard him say these exact words.
But these aren't his exact words, now are they?
They are, yes. In the full portion of the recording, Jonathan Rollins says these words.
But this is not what Jonathan Rollins said, was it?
Not in the 3-second exhibit here today that has not been entered, but in the full court proceedings, Jonathan Rollins says this.
And how come this wasn't admitted as an exhibit then, if you find it pertains to this case?
Objection, Your Honor.
Your objection?
Your Honor, the attorney is asking why a specific recording wasn't entered into evidence and is in no way relevant to the case at hand.
Well, the evidence isn't relevant, or the question isn't relevant about your tactics?
The question is not relevant, Your Honor.
Okay. Response, Ms. Blair?
Your Honor, the witness is testifying to something she did not include in her witness statement or even admit as an exhibit. Therefore, I'm just asking a clarifying question as to where exactly we can find this information.
All right, this is a first-degree murder case. The prosecution, both sides are entitled to question the strategy of the other side, as long as it doesn't invade the attorney-client privilege.
Would you mind re-asking the question?
Yes. This is not what Jonathan Rollins said now, is it?
Like I mentioned, I reviewed the full court proceedings. Unfortunately, in Exhibit 22, these aren't the exact words that Jonathan Rollins says. Although it has the same meaning, I did not prepare the exhibits, and I'm not sure why this 3-second recording does not say those words.
Do you think it's possible that they don't say these words because Jonathan Rollins didn't say these words?
No. Upon my investigation, I heard these exact words come out of Jonathan Rollins' mouth.
And in your direct examination, you said the screenshots were never verified, correct?
Yes.
Yet in your statement, you also said Alex framed Avery when saying, and I quote, since Cifuentes took the time, end quote. You said that, correct?
I'm sorry, would you mind restating that? Would you mind restating that? Just the quotation part?
Yes, the quote was, since Cifuentes took the time to create fake text messages, end quote. You said that in your statement, correct?
Yes.
And in that statement, you just assumed Alex Cifuentes doctored text messages, right?
I said it was a potential, there was potential that Alex Cifuentes doctored these screenshots, although I did not say that that was my final conclusion. They were never verified, so there's no way for us to know for certain.
You understand that you signed this affidavit, correct?
Yes,
And you reviewed it fully, correct?
yes,
Yet again, this quote says, since Cifuentes took the time to create fake text messages, end quote. Meaning you just assumed Alex Cifuentes doctored text messages, correct?
yes.
And what evidence do you have to back up these accusations?
Well, the screenshots were never verified, and Alex was friends with another likely suspect, Blair Rollins. If you would like, I can go into farther depth upon my theory about Blair Rollins and Alex Cifuentes.
No, that's all right. But it's convenient to your theory, Professor Van Owen, that these text messages are fake, is it not?
As I keep stating, there's no way to prove whether or not they're real or fake. In my expert opinion, I believe that it's more likely they are faked than real, as we have testimony, or not yet, never mind. I believe that there is no way to verify these screenshots.
No further questions, Your Honor.
All right, any redirect?
Yes, Your Honor, a brief redirect. Professor, what exactly makes you suspicious of these supposed text messages?
Well, as I keep stating, they were never verified. Despite the fact that the Denver Police Department had the tools to do so, they never verified them. Also, they were sent the day after that they were requested, which is a little suspicious if you ask me. There are many reasons that lead me to believe that these screenshots were faked, doctored, or photoshopped, and they cannot be trusted.
And do you know that these text messages are fake?
I do not know for certain whether or not they are fake. It is my expert opinion. I believe that they were. However, we can't tell for certain as the prosecution failed to verify them.
Thank you, Your Honor. No further questions.
Any further questions, Ms. Blair?
No, Your Honor.
Okay, thank you. Next witness for the defense.
Yes, Your Honor. Is it okay if I ask you if you can hear me, though? I was having a slight issue.
I can.
Thank you. I'm sorry to ask. Okay. The defense would like to call Taylor Perkins to the stand, please.
Okay,
Is it all right?
proceed.
Thank you, Your Honor. Good afternoon, Mr. Perkins. My name's Caroline Dieter, and I'm going to be asking you some questions today. Would you state your name and spell your last for the record?
Yes, my name is Taylor Perkins. That's Perkins. My student name is Macklin Gifford.
Thank you, Mr. Perkins. Where do you currently go to school?
Right now, I'm a freshman at CU Boulder.
And before that, what high school did you attend?
Last year, I graduated from Colorado High School.
And in your time there, did you participate in any extracurricular activities?
Yes, I was a member of the mock trial team for 4 years with Avery.
And were you close with any of your teammates?
Yes, Avery. She's my best friend, still is, and was for all of high school.
And Mr. Perkins, you said you're close with Miss Becker. Is it hard seeing her in this position here today?
Yes, it's extremely hard to see her here, especially because I know for a fact that she didn't kill Coach Brackman.
Could you please tell us, you said your coach was Coach Brackman. Could you tell us how you felt about him?
Yeah, I didn't have the best relationship with him, but that was mainly because of the way he treated Avery. He never gave her a fair shot.
Knowing that, how did it appear that Miss Becker and Mr. Brackman's relationship was?
They had a worse relationship than I did with him, the kind you could expect to have with a teacher who loves to single you out in front of the entire class.
Mr. Perkins, let's talk about the night before the murder. Where were you?
The night before the murder, we were at the Fry Shack, and then we went to the mall.
And while you were at the Fry Shack, did you see anyone you knew?
Yeah, we saw Alex Cifuentes.
Alex Cifuentes, could you please tell us who that is?
Yeah, Alex is another member of the mock trial team from last year, and she went to CHS with us.
And being on the same team as both Alex and Avery, are you able to tell us how their relationship appeared?
Their relationship appeared decent on the outside, but you could tell deep down that Alex really had a way of getting under Avery's skin, and they didn't get along the best.
Now, when you saw Miss Cifuentes, did you exchange words?
Yeah, she came over to the table and we talked briefly, but then Avery got up and stormed off to the bathroom.
Why did she storm off?
Alex was being totally passive aggressive and Avery just wasn't having it. So she went to the bathroom to get away from the conversation.
Was there anything specific that might have stood out to you about this moment?
Yeah, she left her phone behind when she went to the bathroom.
Why did that stand out to you?
Avery never leaves her phone anywhere besides within reach of her, so it stood out to me pretty clearly.
And why do you think she might have left her phone?
Well, she was pretty flustered. She really wasn't having it that day, and then with Alex on top of it, it just was too much for her to handle, so she went to the bathroom.
And did she come back from the bathroom?
Yes, she did.
After she got back, what did you do?
Well, we got up and left pretty quickly after that. Neither of us wanted to be there any longer with Alex than we absolutely had to.
Okay, Mr. Perkins, let's talk about the next day, the day of the murder. Could you tell me how you started your morning?
Yeah, I started my morning texting and calling Avery repeatedly, but she didn't pick up or respond to anything.
And what happened next?
Avery came by my house and picked me up for school, but when I pointed out that she wasn't responding to anything I sent her, we realized that since neither of us knew where the phone was, that it was truly missing, and we went to go look for it.
Where did you look for it?
We started off at the mall because that was the most recent place we had been the night before, but we couldn't find it there, so we went to the Fry Shack afterwards.
And when you were looking around the mall, did you take any extra steps to help aid you in finding the phone besides simply looking?
Yeah, we were texting and calling the phone repeatedly, but no luck.
Mr. Perkins, you said you checked at the Fry Shack. Did you end up finding the phone?
No, we never found the phone.
What did you do after you failed to find the phone?
Well, we just stayed at the Fry Shack for a little bit. We'd been going around all day trying to find Avery's phone, and it was tiring, so we sat down, took a rest.
And this second time at the Fry Shack, did you see anyone you knew then?
Yeah, we saw most of the mock trial team there. They said that Coach Brackman hadn't showed up to practice, and then they left after about 15 minutes because he just wasn't there.
Did anything about this interaction feel unusual or out of place?
Well, not in the moment, but then we found out later that Coach Brackman had been killed, and it was pretty eerie to think that we were actually talking about him while he was either being killed or dead.
I see. And Mr. Perkins, leading up to that point, were you with Miss Becker the entire time?
Yes, I was with Avery the entire day leading up to that moment.
I'm sorry to ask, but would you be willing to lie in Miss Becker's defense?
Absolutely not. Our friendship is founded off of truth, and we wouldn't violate that, especially now. A man is dead. That's no place to joke around or lie.
Finally, Mr. Perkins, do you believe that it was at all possible for Miss Becker to have been involved in Mr. Brackman's murder?
Absolutely not. I was with her the entire day, and we were nowhere near his house.
Thank you, Mr. Perkins. Thank you, Your Honor. No further questions.
All right, cross-examination?
Your Honor, before I begin, may I request a brief time check?
Sure.
Does one of the timekeepers mind chatting how much time is left on the cross?
Timekeepers? There we go, 13.
Thank you. Hi, Miss Perkins. What is your relationship with Miss Becker?
Hi, Miss Fitzpatrick. Sorry to interject, but I am a male. Thank you very much. My relationship to Avery Becker is that she is my best friend, has been for the last 4 years and still is.
And you were on the mock trial team for 4 years, correct?
Yes.
Isn't it true you joined the mock trial team exclusively for Avery?
It wasn't for Avery, it was for me, but I wanted to hang out with Avery, if that's what you're asking.
But you wouldn't have done it without her, right?
Correct. I would not have joined mock trial if it were not for Avery wanting me to try out too.
And then you quit exclusively for her?
I quit because it didn't matter to me if she wasn't on the team. It wasn't fun for me if she wasn't there. But it mattered more to Avery to be on mock trial, and I didn't want to be an attorney anyway. So I stepped down so that Coach Brackman had no chance to bring anyone else in before regionals. Avery was his only option.
So you seem to do a lot for her, correct?
Well, I'm her best friend. It's pretty obvious that I would do a lot for her, yes.
Now, moving to the day Miss Becker was removed from the mock trial team, she seemed desperate, didn't she?
I'm sorry, could you repeat the question? You cut out.
Moving on to the day Miss Becker was removed from the mock trial team, she seemed desperate, didn't she?
Objection, Your Honor. Speculation.
May I respond?
Sure.
This is not speculation because Mr. Perkins was there and can personally observe what happened.
Anything else, Ms. Dieter?
I stand by my objection, Your Honor.
Yeah, your question is whether somebody is desperate or not. That's talking to their state of mind. You can have a witness discuss their personal observations, but we can't get into the head of anyone else on the planet, I guess, except through their actions, or unless they tell you. So overruled.
May I rephrase my question?
I'm sorry, sustained. The objection is sustained. You may restate the question. Go ahead.
Mr. Perkins, what did Avery try to do to get back onto the team?
After she was demoted or after she was kicked off?
After she was kicked off.
Permanently or kicked off A team?
Permanently.
Well, she tried to apologize to Coach Brackman. She had been kicked off permanently for riding on his car, and she had tried everything she could to apologize for him. She offered to get a summer job to pay for new paint, but Brackman wouldn't budge.
Did she text many of your teammates?
Yeah, she texted pretty much the whole team.
Even Alex Cifuentes, right?
I can't tell you if she did text Alex or not. I wasn't part of it. I think she might have, but I can't tell you for sure.
Right. In your witness statement, you said Avery texted everyone on the team, even Alex Cifuentes. I think those were your words, right?
My words were that I think she also texted Alex Cifuentes. You can read my statement and verify that if you'd like.
Yes. And you wouldn't have included that in your statement if you didn't think it was likely, right? Because you want it to be as accurate as possible.
I was told to include everything that was relevant, and being that Alex was going to be testifying against Avery, I felt it was relevant to include the possibility that she had texted Alex. However, I cannot confirm that she did.
Thank you. Now, right on the day before the murder, you believe that Miss Becker lost her phone at the Fry Shack, correct?
I know that she lost her phone for sure, and it's most likely it was at the Fry Shack, yes, because that's the last place either of us saw it.
Okay, but she didn't notice it was missing, even though you referred to her as her third kidney?
Are you asking she didn't notice it was missing at all? Because I can tell you for sure she knows it's missing now. So
Did she notice it was missing that night?
That night, she did not notice it was missing, no. She was pretty worked up, and we spent our time calming her down, and then she went home.
And did you refer to her phone as her third kidney? Is that correct?
Yes, correct. But like I said, she was pretty worked up, and yeah.
The Fry Shack was the last place you saw Avery's phone?
As I've said, yes, it was.
But you believe that she grabbed her phone from the Fry Shack, right?
I never said I believe she grabbed her phone from the Fry Shack. I said that's the last place I saw her, at the Fry Shack with her phone.
So do you think she left it at the Fry Shack?
I think it's most likely that Avery left her phone at the Fry Shack. Yes, it's the last place either of us saw it, as I've said.
However, the next morning you were calling Miss Becker, correct?
Yeah, I didn't know that she didn't have a phone. mean, I didn't know for sure if she left it there or not. It's just the last place I saw it, like I said.
Thank you. So the only person who actually knows whether or not she had her phone is Miss Becker. Is that what you're saying?
Had her phone when, counselor? You're gonna have to specify.
Sorry, the day before the murder.
The day before the murder, I know for a fact that she had it. The
And
day after the murder, she did not.
that she lost her phone the day before the murder. That's my question.
She lost her phone the day before the murder is correct because she woke up the next day, could not find it. I couldn't find it, and then we looked for the whole day and we could not find it. So
But-
lost it the night before, yes.
But you specifically stated in earlier questions I asked you that you did not know whether or not she actually did lose her phone, right?
You asked earlier if I knew if she lost her phone at the Fry Shack, and I said that I do not know for sure it was at the Fry Shack, but I did say, however, that we do know she lost her phone that night.
Because you did not see her with it the rest of the night.
Correct. And then the next day, we were looking for it the entire day, as I've said repeatedly.
But you were only aware of her missing phone when she told you, right?
Well, yes, I did not have her phone with me, obviously. And when I pointed it out, she told me that she didn't have it. And I told her that I didn't know where it was. So we decided it was truly missing.
So the only thing that tells you where her phone is was the person that's most convenient to tell you, correct, Ms. Becker?
Can you rephrase the question? I'm not sure I understand.
So the only person that knows where her phone was is Miss Becker. Is that correct?
Avery doesn't know where her phone was because she lost it.
Sorry, the night I'm talking before she lost it.
Before she lost it, we both knew where it was. It was with her. And then when she lost it, that's when we realized that she didn't have it. That's what losing a phone means, counselor.
But you did not know whether or not she grabbed her phone from the table. Sorry, that's my question. Is that correct?
Correct. I do not know if she grabbed it from the table. I do know for a fact that she lost it at some point that night, though.
All right. Wait, you said you know for a fact she lost it that night?
Yes, correct. I never said at the Fry Shack. I said she lost it that night because
But
she
why would you
the next morning.
why would you call her the next morning if you knew that she lost it?
Because I realized that she lost it that night on hindsight. I hadn't considered that most likely because it was quite possible that she had grabbed it and I hadn't seen her pick up the phone physically. But when she said she had lost it, I said, well, the last time I saw it was at the Fry Shack, which I then concluded from there that that was the most likely spot she lost it because that's the last place she saw it as well.
All right. Thank you, Your Honor. No further questions.
May you redirect?
A brief one, Your Honor. Mr. Perkins, is mock trial that important to you?
Well, when Avery's on the team, it's fairly important to me, but if Avery's not there, I don't really care to be on the team as much.
So was it a big deal or sacrifice when you stepped down for her?
When I stepped down for her, it wasn't much of a sacrifice at all because she was already off the team and it was no use to me to continue doing mock trial. I didn't want to do it without her.
And Mr. Perkins, you said that the last place you saw the phone was at the Fry Shack. Knowing what you know now, are you able to draw a rational conclusion as to what might have happened to Miss Becker's phone?
The night before the murder at the Fry Shack or the day of the murder at the Fry Shack?
What happened to Miss Becker's phone? You last saw it at the Fry Shack, so it would be
Your
the
Honor,
night before.
calls for speculation. Objection calls for speculation.
May I respond, Your Honor?
Yeah, first of all, let me hear the entire question.
Restated from the beginning?
Yeah, I need to hear the question to be able to rule on it.
Oh, no, I wanted to, my apologies. Mr. Perkins, you said that you last saw the phone at the Fry Shack. Knowing what you know now and what you had seen then, are you able to draw a rational conclusion as to what might have happened to the phone?
All right, and the objection is based on?
It calls for speculation. This is asking for the witness to assume facts.
Response?
Your Honor, I'm not having Mr. Perkins testify as to what exactly happened, but rather his rationally based opinion based on his perception of the events that night.
Anything else, Ms. Fitzpatrick?
Also, he wouldn't really have firsthand knowledge of this because it wasn't his phone.
Well, you asked him a whole series of questions that are in this area. This whole area is clearly speculation or speculative, but it is proper to ask a hypothetical question. So I'm going to overrule it based both on the question asking the witness to assume something is a proper form of question, and because it's proper examination following the cross-examination. So overruled. Go ahead.
Mr. Perkins, would you like me to re-ask that?
No need. The most likely thing, in my opinion, of what could have happened to the phone was it would have been Alex, because Alex was there at the fry shack with us, and that being the most likely place that Avery lost her phone, Alex would have seen the phone when we left and would have taken it.
Thank you, Your Honor. No further questions. Thank you, Mr. Perkins.
Any recross?
No, Your Honor.
Okay, thank you. Further witnesses for the defense?
Yes, Your Honor. The defense calls Miss Avery Becker to the stand. And before I start, can we please get a quick time check? Miss Becker, do you know the victim in this case?
I do.
And how do you know the victim?
He was my mock trial coach of 4 years.
And how did you and Mr. Brackman get along?
Honestly, we really didn't, and we often fought.
What do you mean by you fought?
Not physically, of course, but verbally we'd get into it with each other quite often.
And can you recall the last meeting you went to for mock trial?
Yes, it was the meeting right after regionals.
And did you and Mr. Brackman argue there too?
It was the worst fight we had gotten into.
What did Mr. Brackman say to you during that argument?
He basically told me that I didn't deserve the awards that I won at regionals.
And did you do anything in retaliation to those comments?
I did, and it's quite embarrassing, to be honest. I was so frustrated by everything that had happened because despite whatever he might have thought, I did work really hard for those awards. So I stormed out of the classroom with what I thought to be an expo marker and wrote Worst Attorney Award on the hood of his Porsche.
And how did Mr. Brackman react to seeing what you had written?
He was infuriated and immediately kicked me off the team.
Did you try and apologize to Mr. Brackman for what you had said? For what you had done?
Absolutely. I felt awful about it. So I tried to apologize in person, but his secretary said he didn't want to see me. I offered to scrub off the marker on his Porsche and even to get a summer job to pay for a repainting of his car.
Thank you, Miss Becker. Now, let's talk about the day Mr. Brackman sadly passed away. Can you recall where you were the night before?
The night before, I was at the fry shack in the mall.
And were you with anyone?
I was with Taylor, but while we were at the fry shack, we ran into Alex.
Thank you. Now, let's talk about the next morning. Can you tell us very briefly what you had done the next morning?
I remember waking up that morning from a dream into what I later found out to be a nightmare. I woke up and discovered my phone was missing. So I went over to Taylor's house like I normally do, and we decided to skip school to go looking for it. And then later I found out that Coach Brackman had passed.
And were you with Taylor Perkins all day?
I was.
And where was the last place you remember having your phone?
At the fry shack.
Thank you, Miss Becker. Now let's talk about someone you might know. Have you heard of a person named Blair Rollins?
Yes, she attended CHS and we saw each other at school a lot.
And have you ever met her in person?
Yes, we ran into each other at school a lot.
And was she friends with anyone that you knew?
She seemed to be really good friends with Alex Cifuentes.
And Miss Becker, what does Blair Rollins look like?
She looks really similar to me. We have the same height, a really similar build, and even the same hair color.
And Miss Becker, you said that she was friends with Alex Cifuentes. Are you friends with Alex Cifuentes?
No way. Alex and I have never really gotten along, so I honestly have no idea why she's always insists that we're friends.
Can co-counsel please pull up Exhibit 14? Ms. Becker, do you have Exhibit 14 with you?
I have it in front of me, yes.
Are you aware that Ms. Cifuentes is saying that you sent these text messages to her?
I've heard of the claim, but I never sent these text messages. She's honestly one of the last people I would go to for help to get back on the team.
Thank you, Ms. Becker. Can co-counsel please take these down? Now, Ms. Becker, I know you and Mr. Brackman will always arguing. Did you ever get mad at him enough to want to physically harm him?
No way. I'm not a physically violent person, and even though we didn't really get along, I did still respect him.
And finally, Ms. Becker, I am sorry, but I do have to ask, did you in fact kill Mackenzie Brackman?
No, I didn't.
No further questions, Your Honor.
All right, cross-examination.
All right. Ms. Becker, how long have you worked with Mr. Brackman on the mock trial team?
He was my coach for all 4 years of high school.
Would you say the mock trial team was important to you?
Absolutely, yes.
But you got kicked off by Mr. Brackman, correct?
I did after I did a terribly stupid thing.
Is it true that you and Mr. Brackman have butted heads in the past?
Yes, like I said in my direct, we often argued.
Those arguments ever get heated?
How do you mean?
Did Mr. Brackman ever insult you during those arguments?
He often criticized my work and my way of preparing for the case.
Was it commonplace for Mr. Brackman to insult you?
He criticized me at almost every practice, yes.
When he insulted you, you got upset, didn't you?
It hurt when he would say that I didn't work hard enough because I worked hard in my own way. So I guess yes.
Wasn't it true? And then before state, you had a big fight with Brackman, correct?
Yes, that was the car incident, which was so stupid of me.
And wasn't it true at one point during that argument, he told you you weren't a good worker and that made you even madder?
Yes, I did get pretty frustrated that night.
So mad that you stormed out of the argument, correct?
Yes.
So mad that in that instance you went to vandalize his car, correct?
I did write stuff on his car, which once again was so dumb of me.
Would you say those were good decisions?
Like I said earlier, no, it was stupid.
Would you say they were impulsive decisions?
I guess yes, because it did happen in the heat of the moment.
But you did them anyways?
I did do that one thing, yes.
Because you were upset, correct?
Yes, I was upset.
Now, Miss Becker, you claim that you lost your phone the night before the murder, correct?
Yes, my phone went missing.
And you claim someone stole your phone and is using it to frame you for the murder, correct?
It is probable that that happened because when Taylor and I would call it, it wouldn't go through, leading us to the conclusion that it was either dead or stolen.
You're telling me you didn't notice the phone was missing the entire night?
No, I was trying to get my mind off of everything, so I was just trying to be present in the moment with Taylor.
Now you claim Mr. and Miss Cifuentes and Miss Rollins took the phone, correct?
Could you repeat that question? I didn't hear it.
Sorry. Now you claim that Mr. Cifuentes and Miss Rollins took the phone, correct?
I think it could be probable, yes.
And used it to set you up, correct?
Sorry, could you repeat the question? It kind of like slurred the words together.
And they used it to set you up, correct?
Once again, it could be probable.
Isn't it true your phone was an iPhone?
Yes.
So you know generally iPhones have passcodes that you need to enter to use, correct?
Yes, but my password is super easy. It's only...
Now, Miss Becker, you're proud of your mock trial ability, correct?
Yes, I am.
And you were good on thinking on the fly?
I'd say.
And would you say you were good at spinning a yarn, were you not?
When I was portraying the character or when I was in the role of the attorney, I got in the head of the attorney or witness and I could help the jury see the truth behind the case.
No, that's not what I'm asking you. You were good at spinning a yarn, in your own words. Is that correct?
Yes, which is what I did.
Honor, relevance, I don't see how she performed on her mock trial team is relevant to today's case.
Response?
It wasn't only in reference to her mock trial team, it was the idea that this was her own personal characterization of herself and the way that she personally described herself.
Your Honor, may I respond?
Sure.
The opposing counsel is asking how she portrayed other people, not herself, and she is not characterizing herself. Ms. Becker just now stated, in fact, that she would play someone else completely different entirely. So this has nothing to do with who Ms. Becker is.
Your Honor, may I respond?
Sure.
My question was the following. Did she say in her statement, through quotes, that she was good at spinning a yarn? Not through her characters. The question asked for the personal belief of what Ms. Becker thought of herself and her personal abilities. As following, it would be a characterization of herself.
I'll allow it.
Now, finally, you were good at spinning a yarn, were you not?
I'd say yeah.
All right, no further questions.
Any redirect?
No, Your Honor.
Okay. Any further witnesses? Does the defense rest?
Yes, Your Honor, the defense rests.
Okay. People ready for closing argument?
Yes, Your Honor.
All right, you can proceed when you're ready.
That will show him. Avery Becker, 2020. On March 6, 2020, a tragedy struck Mr. Mackenzie Brackman, ending his life and altering the lives of those around him. On this day, an intruder attempted to break into his home. A panicked Brackman searched around the house for a knife, armed himself, and went to go confront the intruder. The intruder panicked, struggled with Brackman through the house, and ultimately Brackman wound up dead. We now know this intruder to be Avery Becker. At the beginning of the trial, you heard what we're going to prove, that not only did Avery go to Mr. Brackman's home out of revenge and anger, but in a fit of panic killed him. At the start of the trial, you heard what we're going to prove, that Avery Becker had been at Mr. Mackenzie Brackman's house on the day of the murder, attempting to break in out of spite. Once confronted by Brackman, struggled, stabbed Brackman, and left. As the prosecution, we carry the burden of proof beyond a reasonable doubt. And throughout this trial, we have established all necessary parts of a crime beyond the reasonable doubt. Through our expert witness, we explain why Avery was in the location and vicinity she would need to be in to commit the crime. Through our other expert witness, we explain why forensic evidence left on this crime scene points directly to the defendant as the perpetrator. And through our third witness, we've explained the ways in which Avery outwardly communicated the idea that she was going to break into Brackman's home, and she did just that. In comparison, the defense's primary expert witness acknowledged, firstly, that we had rationale and reasoning and enough evidence to make Avery Becker a suspect. They also conceded that they made several assumptions, the very thing they claimed our credible witnesses did. The singular alibi, an only person who could prove Avery Becker not guilty, frequently and warped their story, continually changing and submitting multiple truths, and proved themselves entirely unreliable as a representative of the objective truth. And even the defendant herself admitted that she was good at spinning a yarn and that she would do things out of anger and impulse. Now, the entire defense's case rests on the idea that the phone was missing in the first place, yet the phone's location was far from confirmed as lost. The only person claiming the phone was lost just so happens to be the person it best serves that claim for. The only other person who made this claim, the defendant's best friend, a friend who characterized the phone as Avery's third kidney, a friend who acknowledged that they had no idea where the phone was the entire night it supposedly had gone missing. They also acknowledged they had no idea the phone was even missing until the defendant made a self-serving statement and claimed it was. They also explained the ways that they had no assurance the phone was ever missing in the first place. Now, the defense wants you to believe in the improbable, but here's what we do know, that Avery Becker's phone was at Mr. Brackman's home on the day of the murder. And we know that it is beyond reasonable that Avery could have been with her phone on that day. For these reasons, and for the inconsistencies of the alternative narrative, I implore you to seek justice for Mr. Brackman and deliver a guilty verdict of Avery Becker. Thank you.
Thank you. Fence, have a closing statement?
Yes, Your Honor. May I proceed?
You may.
Thank you, Your Honor. In an instant, Avery's dream came tumbling down around her, leaving her to stand alone among the wreckage. The people she thought were going to help her pick up the pieces were the very ones burying her deeper. No matter how hard she tries, how much proof she can give, she can't escape this nightmare. No one cares. The prosecution has the burden of proof here today, which means that in order for them to convict Miss Becker, they would have had to show you, beyond a reasonable doubt, not just one, but all of the elements involved with first-degree murder. Avery Becker started her day off like any other. She drove to get her best friend, Taylor Perkins, and take him to school. When these two friends realized that Miss Becker's phone was missing, they drove to the mall. After frantically calling and texting the phone with no success, they realized that the last place they had seen it was the Fry Shack. So they walked over. They wanted to check their table. The very same table that Alex Cifuentes sat down at and used Miss Becker's phone. The prosecution's entire case rides on one main thing. That thing is this missing phone that was last seen in Miss Cifuentes' hands. The prosecution expects you to convict Miss Becker based on their sloppy case and sloppy investigation. They corrupted important evidence beyond retrieval. They want you to trust Kyle Kuzak's testimony here today when she herself didn't even know what evidence was found at her crime scene. They want you to forget about the fact that they accepted unauthenticated screenshots from an incredibly biased witness, hoping that she was what? Acting in good faith? Your Honor, ladies and gentlemen of the jury, the sad truth is that the prosecution here today has no true desire to solve this case. Their desire is to come to the quickest conclusion and move on to their next case, even if it means convicting an innocent person. But that is because Miss Becker is not a person to them. She is a statistic. And another tally to be penciled into their records. But ladies and gentlemen of the jury, Miss Becker is a person who has done everything in her power to show the government she is innocent, yet they simply refuse to investigate. You heard Professor Blake Van Owen offer a far more motivated suspect in this case, Blair Rollins. Kyle Kuzak indicates Blair Rollins as suspect number 3. No physical or DNA evidence was found linking Miss Becker to the scene of the crime. The same cannot be said for Miss Rollins, however, because even as a suspect in this case, she was not investigated. She did not have to come in for an interview. She did not have to submit DNA, and she certainly did not have to provide an alibi as to her whereabouts at the time of the murder. When you leave here today to make your decision, remember that Miss Becker has shown through her own testimony and that of an eyewitness that she was at the mall during the crime. The prosecution has nothing tying her to the crime scene, meaning that it would have been impossible for Miss Becker to have broken into Mackenzie Brackman's house, impossible for Miss Becker to have been the one with the intent to commit criminal mischief against him, and impossible for her to have been the one to ultimately kill him. The Brackman family deserves peace and justice, and they can never have that with his true killer walking free. The prosecution has not shown you a single one of these elements today. We're asking that you find Miss Becker not guilty. Wake her from this nightmare. Thank you.
Thank you. Any rebuttal?
Yes, Your Honor. May I begin?
Sure.
Again, the defense makes unfounded claims, and they continue to try and have you believe that Avery was innocent through this entire narrative. Yet we heard Avery earlier today saying she knows how to spin a good yarn, and that's what this entire trial has been for her, a yarn spinning that the defense wants you to believe in. Yet Avery continues to lie and misrepresent the ideas. She lied about talking about this, about the idea that her phone is missing, and she's lying about being the intruder, and she lied about being the perpetrator. I wish that you as a juror hold Avery Becker accountable for her actions that she has further been proven throughout this trial through forensic evidence. And I once again ask you to find Avery Becker guilty.
All right, thank you. And thank you to everyone. If we had a different forum, I think we would all be clapping loudly, but makes it a little difficult to do so. We'll let our scoring panelists finish up their scoring, and I'll give you a few comments. First of all, make sure when you go home tonight, think about everybody in your house that you kind of imposed on, your parents, everybody you practiced in front of, all the time you've spent on this and not done your chores and other kinds of things. Make sure you thank your support staff. If you think about it, it takes a lot of people in your lives to get you here and able to do this. I thought everybody did a wonderful job. I've been doing this for more than 25 years. I enjoy this all the time. It's a new case every year. This case is quite difficult for a couple of reasons. There's a couple of ways, like your case played out completely different than the one I saw this morning. There's a lot of ways to go. And part of that is there's so many facts, and there always is a lot of facts in the mock trial scenarios, but there's an awful lot of them here. And, you know, I know from trying cases for more than 30 years before I became a judge, the most important thing is taking all that information and putting it down into a cogent theme and being able to present it in a rational sort of fashion. I did a lot of complex medical malpractice cases. You end up with lots and lots of depositions, usually, which are like your witness statements here. Sometimes they conflict. There's always a lot of records. There's a lot of experts like you had here. They're almost always doctors. Guess what? Doctors have no shortage of opinions. They have many, many opinions. They have an opinion on anything. Just ask them. And then you have research. But probably the most important thing, and both teams did a good job here, is the human story. The human story here is what makes a difference, because the prosecution case is entirely circumstantial as to the defendant. I mean, it's very clear there was a death, where it happened, what the weapon was, but it's all circumstantial as to the defendant having done it. That doesn't mean that's not okay. But then the defense is kind of left with this sort of self-defense theory through their expert. And self-defense is hard to prove in the most ideal situation. And here you have to try to prove self-defense without admitting that the defendant was there to even be participating in the self-defense. So it makes for a lot of interesting things how the case turned out. One thing I'll say just as an observation, and it may be important if either or both of your teams end up going on from the regional tournament, and I don't fault anybody for this because it came in and it was within your fact pattern, but actual defense lawyers and judges like myself, you'd be doing a backflip over the question about why didn't the defendant offer an alibi, didn't participate in the statement. I mean, that's a clear Fourth Amendment violation. We all know the Miranda warnings. That's what that means. You don't have to incriminate yourself. So that would have been a mistrial had that been the way an actual case unfolded. That would be a violation of the defendant's Fourth Amendment rights. So I say that just because it's interesting, perhaps, to you, and that's how that comes up in real life. It doesn't always just come up like, oh, I said I was going to remain silent and you asked me more questions. It comes up in kind of a little more, subtle ways from time to time. It's unfortunate, of course, that we had to do this by Zoom. There are some good things. You guys get to kind of use notes and nobody knows it. You can use a split screen and nobody knows what you're looking at. And you don't, the one thing you don't get is kind of the nerves of standing around in the courthouse in front of actual people as opposed to just literally talking to your laptop like we're getting used to doing. So it would be much easier to talk to 5,000 people on your laptop than it would be to talk to 5,000 people in an auditorium. So too bad you didn't get that. Hopefully you'll continue if you're not a senior and continue and do more mock trials, and hopefully we'll be back to normal next year. I would say for anybody who's a music student, use the whole modulation idea. I'm a musician, and the silences between the questions and the sounds and the notes in music are what makes it interesting, and things getting louder and quieter. So sometimes people get to one kind of voice. It's either very low. Low is good because you can always go up when you want to emphasize something. But if you start high and you're going at something 100 miles an hour, or especially last round, I had somebody who just literally screamed their opening. The problem is when you scream everything, nothing's important then. So, make use of that opportunity to emphasize things. Let's see. I think I'll let our other scorekeepers, are you all ready to give some comments? We'll go alphabetically. Ms. Kanskis.
It's close enough, Judge. Thank you. I think you guys did great. This is a very interesting year to do these mock trials. This is my third or fourth year. I cannot remember. I always love participating in these. I want to say I've seen a couple of you before. I think so previously. Maybe Sadie, maybe I've seen you before. And it looks like, people are advancing and in their skills and their presentation and the technique. Judge Stevens is absolutely right. We don't have that moving in the well sort of situation where you can, or actual portrayal of evidence using a little bit more, sometimes called theatrics, sometimes it's just called strategy, sometimes called technique in litigation and trial presentation. So we're lacking that, but I think what you guys did is we're able to transform, the attorney and the witness conversation for the jury and with the best tools that you had in the best possible way. I'll say a few things. I mean, I can talk all day, but I have a couple pages of these, but couple of things to remember going forward. Stop interrupting your witnesses. I think Judge Stevens called upon one of the attorneys earlier, and he says you have to let them finish answering. And if they are rambling on, it's because you did not ask the right question. So ask the right question and you'll get that yes or no answer that you actually want. Also, I think who did the opening for? It was Kira for the defense did the opening. And I think you said you counted, it was like 6 things that they need to prove, or 6 things that There was something about 6, and I wanted to see that from at the very end from the closing argument, and I was just missing that, the tying into the beginning of your story, the beginning of your case to the end. That's sort of what was a little bit missing. Also, if you get an exhibit admitted, use it. That's what you worked this whole line of questioning for, to get it admitted. Publish it, use it, do something with it, just so it's not sitting on the pile on your desk. Speculations. It is a proper objection at trial. Don't forget to use it. And I think Judge at the very end called one of the attorneys out and said, well, you just went on a 5-minute questioning about speculations about where the heck the phone was, and it is a proper objection. And if you think you're going to draw an objection of speculation, add something that, to your knowledge, or based on your observations, or based on your own personal perspectives, that will be a little bit harder for the other side to object on speculations. Other than that, great job. I hope to see some of you at some point later in life.
Thank you. Mr. Byrd?
Yeah, I agree with all the advice you've heard so far. I want to tell you guys that you did a really good job. I thought both teams did a really good job today. Specifically, I think that I've been in all 4 rounds, and the previous 3 I've been in had a lot of problems with reading. And I don't know how much you guys were reading, but if you were doing a very good job of covering it up. And it's always okay, in my opinion, to check your notes every once in a while, but to just be reading a script is not acceptable. And I thought that you guys were the best group that I've seen as far as that. But you might have been the worst group as far as adding tags onto your questions. Isn't that true? Isn't that correct? Right? After every question, you would add one of those, and you really don't have to. You can just ask the question, and you can let it be silent for a second while the witness prepares to answer. And here's something that's come up before is I feel like on closing, the prosecution kind of did the defense's job a bit. You were talking about the burden of proof, and how you had to prove beyond a reasonable doubt, but instead you can just talk about what you did prove and let the jury assume that you have met your burden of proof, and then you force the defense to really hammer home that no, they had to meet beyond a reasonable doubt. You kind of did that for them. But besides that, I really thought you guys did an excellent job, and I really appreciated how prepared everyone came across in terms of I saw as little reading as I had seen in the last 2 days. So good job, everyone.
Thank you. Ms. Ryan?
Thank you, Judge Stevens. I think both of you did a great job. I mean, this is really hard. It must be great to have the 4th round done and you can relax for the rest of the day. I do agree that prosecution, when you start out and you say that somebody's going to be guilty, tell us, what we're here to do. Are we, assault, battery? We didn't hear anything in the opening that said, why we're here and what we're supposed to find somebody guilty of. But then the opening on the defense side, they said, yes, we have these 6 elements and we're going to, show that they don't have these 6 elements. But then it didn't follow through with the questioning of the witnesses or in the closing. So that wasn't all tied together. But I agree with Eve. If you get an exhibit in, use it. Prosecution got exhibit 5, 18, and 9 in, and then dropped and went on to something else. Also, when you're trying to get an exhibit in, like exhibit 14, defense did object, but your actual objections that would have worked would have been no foundation or improper foundation, because they hadn't laid enough foundation to try to get it in. But those are technical things that you learn through the years of trying to get exhibits in, but use them. I would have liked to have seen the knife. You got it in, show it to me. But a lot of open-ended questions on defense, which you don't want to do. Strictly keep it to yes, no, keep the witnesses under control and don't let them say whatever they want. That kind of used up a lot of your time not getting information in that you could have gotten in because your witness was off on a tangent. But great job. Be proud of yourself. If you're not a senior and you get to do this again next year, we hope to see you again. And great job. I hope you both get to proceed in the next rounds and go to regionals.
Well, thank you. And I know you're all anxious to be done, but now that we've made it through these rounds, and I'm going to sit through this next week in Douglas County because we're doing it with that tournament next week. I just had a couple, I'll just say them to say them. And maybe the lesson in life is, as it often is in the legal field, to keep things simple. The simple things that I have yet to hear about this case are things like, where is the knife in the person coming in the back door? I mean, where is it? Is it stuck in his leg? I mean, that's a huge knife, you know, is it inside the jacket? And if you're going to come in and you're attempting, or you're going to murder somebody by stabbing them in the back, why wouldn't you have that knife out? It's not out in that picture, is it? So that seems to be a simple thing, and don't overlook the simple things. Another one is, even if the victim, I might consider this question, if the victim was stabbed from behind, as is consistent with the defense theory, then how does that mean that the defendant here didn't do it? I mean, just ask the question of that one expert. Who cares what the answer is? You've at least suggested the theory. So those are my parting comments. And with that, enjoy the rest of your weekend. Hope to see you all again. Hopefully you enjoyed yourself and most importantly had some fun. And as I said at the beginning, make sure you thank everybody who helped you, okay?
Thank you, guys. Just so
Bye
the
now.
students
Thank
know,
you.
all your teachers will be getting your scores via email. That's how you're going to know where you guys stand, okay? Congratulations for all your hard work, and we hope to see you next year.